Good morning to all of you. Andariki Shubhodayam. Welcome to Legal Matters by Sai Babu Sunkara. IT Act. The point is whether the magistrate can order deletion of certain portions of the so-called exhibited material. Magistrate cannot issue the order of stoppage of the online control, online publicity under section 69A of the Information Technology Act. This is a decision by Honorable Supreme Court of India. You may be knowing presently so many the so-called celebrities like Pawan Kalyan, Sanakir Anandan, and so many Julian Shah, so many people they are approaching the Delhi High Court to protect their personality rights, data protection కింద వెళ్తూ ఉన్నారు. Most of them are being given and are 13 injection order కూడా ఇస్తుంది. Here the point is whether magistrate can do such things. High Court అంటే ఓకే, magistrate cannot do. 69 of the IT Act ఒకసారి చూసుకుంటే మనకు అర్థం అవుతుంది. But anyway, దీంట్లో still the decision is not taken regarding the jurisdiction. The matter has come to the level of the Supreme Court, 3 judges bench. Chief Justice of India, Justice Suryakanth, Joymala Bagchi and Vipul Pancholi. In the case of Dhyan Foundation versus Google LLC and others, SLP number 2497 and 2498 by 2026, held that Honorable Supreme Court of India yesterday held that clarified that magistrate has no authority to issue gag orders under 69 of the IT Act to remove the alleged so-called alleged material which the Dhyan Foundation wanted to get it removed. If you know the facts of the case, you can easily appreciate the matter. Dhyan Foundation is a registered charitable non-governmental organization. This foundation is engaged in animal protection, animal welfare activities, and actually when people are doing something, it is always quite common that the reversal or the comments on them, adverse comments on them also take place. In the YouTube, certain people left 5 videos which have become viral. Right? In the Bombay city, some people, so they have made videos which are derogatory, which are containing false allegations or false imputations against Dhyan Foundation. Therefore, these false allegations will definitely damage their reputation. Therefore, they approached the magistrate court or municipal magistrate court at Ballar, Mumbai, and requested them to give an injection order, requested to remove the so-called 5 videos containing fake imputations. Because they are being broadcasted. If they are broadcasted, their reputation will go down. On 31/3/2023, Honorable Metro Magistrate directed Google to stop and remove the so-called contents or stop and remove the circulation of videos. And at the same time, the magistrate directed the state to consult Google because they have got a dedicated public relations officer in this aspect as per IT rules 2021. But no action. The YouTube videos are still continuing. So therefore, Dhyan Foundation once again filed another complaint. Almost this is like the so-called contempt. Even though Honorable Court was pleased to direct the Google to remove the content, to stop publication of the content, they are not taking care. They are disobeying the order. And once you disobey the orders, it amounts to Contempt Act under 1971, Section 12. Right? So in this connection, the Google company, they filed a revision petition. So before the High Court, right? Google, of course, they have filed the so-called petition with the delay of 116 days. Of course, it was allowed. And the revision in the Sessions Court, actually, they stayed the so-called contempt proceedings also. So, not satisfied this, the Dhyan Foundation, they have challenged the interim stay. We asked them to remove the content. On that, you are giving stay orders. What is the use? So, ultimately, they came to the Supreme Court. And now, the Supreme Court, please remember, clearly stated that it is the Sessions Court which has to decide. It is the High Court which can decide the jurisdiction. One part. Of course, Supreme Court cleared that magistrate has got no jurisdiction, only central government. Authorized officer, section 69 of the Information Technology Act says. So, the center is competent to direct the exhibitor, to direct the publisher to suspend the operation of particular thing. And also 69A, no doubt, it empowers the authorized officer on behalf of the center to direct blocking. So, of course, magistrate jurisdiction is not there. But anyway, High Court wanted to take up the matter whether magistrate has got jurisdiction or not. So, as stated in the case of State of Tripura versus Sri Saumen Shankar, so please remember, magistrate lacks jurisdiction to direct the company to block the so-called videos. Of course, Sessions Court has made out a good point regarding the jurisdiction, and the power to condone, it's quite simple. It has got Section 5 of the Limitation Act says gives umpteen power to the court. But anyway, the Bombay High Court observation is set aside. Now, in this case, it is very clear that magistrate court has no jurisdiction to ask the content to be removed. Only central government are authorized. If you know on this much, it is sufficient. Thank you.